Attorney Yanez, whenever you're ready to proceed, you may call your first witness.
Yes, Judge, I'd like to call Mr. Lusby as a witness.
All right,
Sir, can you please state your name for the record?
Rocky Justin Leslie.
hold on one second.
Justin.
Yes.
Can that, matter of fact, can you use this one?
Yeah, of course.
Yeah, that'll be
Am I
easier.
loud enough?
You can leave it right there. Yeah, there you go. Sorry about that. You may proceed.
Thank you, Judge. Sir, can you state your name for the record?
Rocky Justin Leslie.
And Sir, Mitchell Salas is the petitioner in the suit for modification of a parent-child relationship. Is that correct? And you're the respondent, correct?
Yes.
Now, the child, the subject of this suit, can you tell us her name?
Catherine Leslie.
Catherine was 15 at the time this suit was commenced. She's now 16, correct?
Yes.
In the underlying suit, Mr. Lusby, you were the conservator who had the exclusive right to designate Catherine's residence, correct?
Yes.
Do you recall that after temporary order hearings were held in this case and after the child was interviewed, that custody issue was flipped?
Yes.
Isn't it correct that after temporary orders, it was Mitchell Salas, the mother of the child, that was granted the exclusive right to designate Catherine's residence, correct?
Part of temporary orders.
And
You have to speak up. I can barely hear you, Mr.
That's part
Elizabeth.
of temporary.
Thank you.
Pursuant to those temporary orders, Mr. Lusby, you were granted possession of Catherine following the standard possession order, correct?
Yes.
And Mr. Lusby, since the entry of those temporary orders in January, you have chosen not to exercise any periods of possession with Catherine. Isn't that correct?
Yes.
As a matter of fact, Catherine's birthday was in March. You didn't visit her during that possession time, correct?
I still do it.
Did you visit her, sir?
No.
Now, you've talked to her over the phone, isn't that correct?
Yes.
And your relationship with the child isn't as cordial, correct?
It's hard to tell.
Prior to the temporary orders in January of 2026, Catherine was living at your house and visiting with mom on a regular basis. Would you agree with me?
Yes.
And prior to that, these orders being in place, Catherine even had a room in your house, correct?
Yes.
And sir, since the temporary orders, you've chosen to pack up all her things, correct?
Yes. True.
And Catherine has insisted on getting her clothes and her personal items out of your home, and you've denied her that request, correct?
I told her to talk to her about it.
Have you given her clothes and her personal items?
No.
Now, do you recall that part of the issues between Catherine and yourself was that you've remarried and she doesn't feel safe near your new wife, correct?
Can you repeat that?
Do you recall Catherine stating that she doesn't have a good relationship with your new wife?
That's an objection on the hearsay. Catherine's not here.
Sustain, rephrase.
And sir, do you recall there were police reports that were made for property damage because your wife broke Catherine's phone?
But it's the same thing that my wife and my break follow.
Okay, but you recall there being a police report that accused you of such things.
There was a police report.
In fact, you even paid for that phone that Ms. Rosales had bought for your daughter, correct?
I made a payment.
And sir, since the entry of the temporary orders, you and mother were ordered to communicate through a parenting app, correct?
Yes.
And you've refused to abide by those court orders. You haven't even downloaded the app and communicated with my client,
That's
correct?
not true, Donnie. Yeah.
When was the last time that you communicated with Ms. Rosales? If you can recall, was it in the last month?
It's been a couple months since she hasn't communicated with me either.
Now, sir, what do you do for work?
I work for the city of Dallas.
And what is it that you do with the city of Dallas, sir?
I work for the fire department.
And I'll point you to Exhibit 4. Is this a copy of the pay record that you've provided to me regarding your base compensation with the fire department?
That was provided earlier in this proceedings.
Okay,
Yeah.
sometime around February of 2026 when you were still represented by attorneys, correct?
Yeah, actually, for that.
Now, in Exhibit 4, sir, which has already been admitted, your base pay is that of $118,627.89, correct?
627.
With 89 cents. Thank you, sorry. Correct?
That's what that says.
Through your employment, you receive bonuses as well, correct? I'm going to show you what has been file marked and already admitted as Exhibit 3. Do you recognize that as the pay that you have shown us for 2025, showing that you had made $125,183.57.
I did provide that.
That's what you earned in 2025, correct?
That's just a,
Objection non-responsive.
Sustain. It's just yes or no.
That was not your pay in 2025?
if you give me an opportunity to explain that document.
Sir,
You'll have an opportunity, sir. You'll have an opportunity.
That's not necessary. That's my annual salary, yes.
that was your annual salary in
Yes.
2025, despite Exhibit 4 saying your base pay was $118,000, correct?
Because that just shows the base pay.
Because you are earning benefits separate and apart from your base pay, correct?
Yes, not bonuses, but yes.
Now, sir, in 2026, have you received, are you earning about the same, more, less?
I'll provide that as part of my activities, as well as an update.
Okay, my question again, sir, is in 2020,
Slightly more.
slightly more. Do you know how much you've earned thus far?
Not a ton.
Now, it's been quite difficult to get documents from you regarding your pay. Would you agree with me, Mr. Lustig?
I do not.
I'm going to show you what has been marked as Exhibit 2. This is a copy of the responses to production that you provided to us. Is that correct?
Yes.
And a lot of which, almost all of them, had objections. Do you recall that?
I do.
Do you recall we had to have a hearing on a motion to compel on this issue?
I do.
And after that, you still didn't supplement your responses, correct?
I did leave.
I'm going to show you what has been marked as Exhibit 6, already admitted. On April 8th, we had to send you another deficiency letter regarding your responses to discovery. Do you recall receiving this?
I do recall seeing a letter of all date.
And no supplements were made after that date, correct? Now,
I sent pay statements.
Now, sir, one of the main reasons that we're here today is that you're contesting that you should get some kind of reduction based on a pension contribution that you're making with the fire department, correct?
Yes, lawfully, that's part of it.
Objection, non-responsive after yes.
Sustain.
Now, do you recall that in one of the hearings that we had, Judge Lee awarded you such deduction because she said she wasn't sure if you actually were to receive that deduction pursuant to the code?
Yes,
Okay, and do you recall that after that hearing, both you and the opposing attorney from my office were ordered to produce case law or evidence to show,
that's not true.
sir, isn't it true that both of you were ordered to produce information to substantiate your claims? Okay, so after the hearing, sir,
There was no.
Objection, non-responsive.
Blank case.
Sustain. Wait for the next question, Mr. Lusby.
Sir, I'm going to show you what has been marked and already admitted as Exhibit 9. Do you recall that Judge Lee even conferred with Office of the Attorney General Justin Dale regarding this deduction?
I do recall the email thread.
Okay, and you recall Mr. Dale said that the Office of the Attorney General, in fact, did not give credit for these pension contributions.
Let's look at what that says, if you have that.
Sure, I'm going to show you what has been marked as Exhibit 9 and already admitted into the record of the court. Oh, let's look at Exhibit 9. Do you recall after that hearing, sir, you provided Judge Lee with a series of cases that you said supported your position regarding that contribution?
There was stuff that I looked at there. Yes.
Okay, and do you recall you cited List v. List, the other sections of the Family Code, and other cases that you say substantiated your claim?
Yeah,
Okay, now do you recall that I informed both you and the court that those cases didn't exist and that they were made up case law by artificial intelligence?
I guess.
So tell me, sir, do those cases in fact exist?
I
You don't know,
think.
but you made representations to this court that those cases supported your position, correct?
It was an email thread. It wasn't for hearing.
Okay, did you or did you not email them to Judge Lee?
That's part of the email thread.
Sir, do you recognize or do you understand that by you citing these cases that don't exist and me demanding, just send me a copy of the case, you sent me on some kind of goose chase trying to find these cases that, so according to you, supported your case law to this court that you were supposed to get this deduction.
I would not answer that. It's essentially a use case. It's 20 years old.
Sir, isn't it correct that we're here today because you are demanding that you get that pension reduction?
As part of Texas case law.
Okay, and that is the only reason why we're here set today.
No.
Okay, we're here set on my attorney's fees as well.
Yes.
And you understand that Mr. Dale of the Office of the Attorney General and Judge Lee have already told you that you are not entitled to that pension.
No,
They have not made such rendition. Do you recall Judge Lee saying, hey, I recognize I shouldn't have given you that deduction?
exactly what you said.
Sir,
That she wasn't sure.
Sir, I'm asking you a question, objection non-responsive.
Sustain.
Do you recall in the last hearing we had with Judge Lee, that Judge Lee said, I recognize I was wrong. You are not supposed to get that pension deduction.
That'd be hearsay, Judge Lee's not here.
Okay. Sorry, Judge.
Objection.
Sustained.
Wouldn't you agree that that was a ruling of the court, sir?
No,
That was not a ruling of the court according to you.
no.
So exhibit 9 and exhibit 8, which have already been admitted. Oh, let's look at. Sorry, Judge.
That's okay. I have a question while you're looking for what you're looking for.
Sure.
Mr. Lusby, you quoted something here out of 154.062, subsection E.
Yeah.
Well, let's start at D.
The non-discretionary.
Yeah. Does your employer require you to contribute a certain amount to your pension in order for you to maintain employment? Do you have that somewhere from your employer?
I haven't shown reductions in my paycheck.
Okay, that would be the issue right there, because the code specifically under E, it talks about the non-discretionary retirement plan, and then in F, it further explains subsection D number 6 and says a non-discretionary retirement plan is a plan to which an employee is required to contribute as a condition of employment. So in essence, in order for you to maintain your employment with the city of Dallas as a firefighter, you have to contribute this amount to the pension.
That's my testimony. That's
Okay.
However, those documents have already been requested of him for the discovery, and he has provided nothing to substantiate that it's required.
Okay.
So,
Okay.
specific.
Well, you may continue, counsel.
Now, sir, you also sell cattle for a living, correct? You don't sell cattle as a form of side hustle? How many acres of land do you live in, sir?
24.
Okay, how many cattle do you have?
How many
I don't-
acres?
I don't.
21 acres.
How
Okay.
many animals do you have in those 21 acres?
3 dogs. 2 cattle.
2 what, I'm sorry?
2 cattle.
2, so you do have cattle.
They're not on. There's 2 cattle on the land. I do not own the cattle.
Sir, as part of the request for production, we also requested your bank records to show any self-employment income that you might have.
I do not have any self-employed.
And you didn't produce those bank records, is that correct?
I did not.
I'll pass it over to you.
All right. Now, Mr. Lusby, you can choose to have testimony now based on the question and answers that Attorney Yanez you all just had, or you can wait until after she rests and your case in chief begins and then tell me what you would like for me to know. It's up to you.
Do I have the option to do both? Like, can I?
Yeah.
Okay. So as far as the questions, as part of my testimony, as far as the questions she asked me, I do not own cattle as my testimony. I do live on the land. I do not own the land. And I have no income from any cattle or business. That's my testimony. Also, as part of my testimony, to my understanding, Judge John Lee never made a ruling on the pension. She did say that she wasn't sure if she made the correct ruling, but when we had
Objection hearsay.
Sustain.
to my knowledge, when we had a hearing and the judge made a ruling on not child support, she stated, or it was stated that she's leaving the deduction for the pension as part of it for now. So in my opinion, that meant that she hasn't made a ruling against it, but she did not state that. Also, as part of my testimony, if you look at the email from the Attorney General, he compares my pension contribution to like a 457 or something, which it's not. So also, as far as that, I also do not pay Social Security. Pay Social Security because we're showing my W-2 and also my pay statements, which part of mine is, and which I have submitted to them many times, paychecks, and also tried to confer with them on finalizing this whole basically get a final agreement on everything before we get the trial, and never got any type of response from them. That's part of the reason I don't feel like I should have had to pay their attorney fees. In my opinion, it shouldn't be here. It should be it's dealt with.
May I, Judge?
Yes, briefly. Hold on one second. Briefly, I meant me briefly. Where do you believe that mom got the idea about you selling cattle?
I don't know.
You're saying she made it up?
That's it.
Maybe your daughter, where would your daughter have gotten that from?
I mean, there's cattle here, but I don't have any cattle.
She's never overheard a conversation with you talking about selling cattle?
My wife has cattle. My wife, I do not.
Oh, okay.
Judge, they're minority community.
Mm.
My spouse's income do not be considered large household. That's very written law.
And that is true?
The sale of community property is community.
No, she's gonna be-
Yeah, but
But she just testified that there was no cattle, and then he turns around
I
and
said
said,
there
no, he didn't say that. He said, I don't own cattle. That's what he said.
that's some how many were on property.
You asked him how many are there? He said, well, let me scroll back. I can tell you exactly what he said. You said, now, sir, you also sell cattle for a living, correct? He said, I do not. You don't sell cattle as a form of side hustle. I do not. How many acres do you live on, sir? 21. How much cattle do you own? I don't own any. How many animals do you have on those 21 acres? There are 3 dogs and 2 cattle. 2 what? I'm sorry, 2 cattle. So you have cattle. They're not mine either. Don't own them. That's what he said. Okay, that was my question. Counsel, you may.
now, sir, if you can look at Exhibit 8, which has already been admitted, let's read this email Judge Lee sent to both you and Mr. Olvera of my office. Good morning. I've spoken with a few other AAGs, and it is the OAG's position that the father should not get credit for the pension payment because it is not a listed deduction exception in the family code. She lists a family code provision. We don't give people deductions for 401ks or Roth IRA investments. Technically, the pension payment is still father's money. It's just being placed in a fund for him. However, I have still not found the case in point. TFC may be helpful, but I'm not sure. So again, sir, do you recall Judge Lee saying you are not to get credit for that pension contribution?
I do not recall Judge Lee saying that.
You don't recall receiving this email from Judge Lee, sir?
I recall her saying this is the response from the Attorney General, but
Okay,
she's not in no part of it. She say, and therefore I am reversing my decision.
yes, and we agree. She did not reverse the decision. She told you it had to be fixed in final trial. Wouldn't you agree with me?
Yeah.
She said it numerous times. You weren't supposed to get credit for that pension contribution.
No, she said she wasn't sure.
Okay, I'll pass away.
All right, anything further based on the testimony you just gave?
Yeah, I just want to point out that it clearly compares that my pension contributions to a 401k Roth IRA. Maybe he was a little misunderstood on what they were. And then he points out to 154.062B6. Right, and as part of my testimony, I have been given credit for my pension contribution before, prior in this court,
And,
as a part of the Attorney General's.
and let me just, and I'm glad that you said that. Just because something happened
Yeah.
prior doesn't mean it should have happened. And one thing I'm big on, I do my best to read the law, follow it for what it says. So I can't make a ruling based on what a judge did before me, because that doesn't necessarily mean that it was correct. Not to mention, the law has changed so many times, specifically child support. So anything could have changed. As far as I can remember, I never remember a pension specifically outside of a non-discretionary retirement plan being one that was given credit from the state of Texas. That's as far as I remember.
I have one more question, Judge.
Go ahead.
Sir, since January, you have not made any child support payments to your daughter, correct?
Yes.
You have
I
not?
have not.
You have not, and you've also not visited her, correct?
True.
Would you agree with me that not visiting costs maybe an increase in the expenses Ms. Rosales has for your child?
No.
And you're not paying any support for this time, correct?
There was not a word income withholding order in her.
And you don't think it's your obligation to pay support for your child, even if there's no income withholding order?
You have 2 minutes.
It clearly states that there should be an income withholding order and that you make payments directly to the Attorney General, which you can't do if you don't have an income withholding order at the case. At the time, she was still reporting to the Attorney General.
Okay, objection narrative.
Sustain. And to your point, Mr. Lusby, yes, there has to be an income withholding order in order for your employer to withhold the money out of your check. However, the obligation is still there. So even if withholding has not occurred, you still have an obligation to make sure that mom receives the money. Even if the state disbursement unit hasn't received the proper paperwork yet, the order, all the things, there are options that you have to make sure that she receives the money. You could open up a court registry with the county. You can make direct payments to mom, and mom can do an affidavit through her attorney to make sure you receive credit for those payments. So I don't want you to die on that hill of there not being an income withholding order, because as long as an order said you were supposed to pay child support, that triggers your obligation.
I understand that, and they had the option to file an income withholding order back in February, and they never did it. For whatever reason, I have no idea.
Well, that's beside the point. The point is this: your obligation was triggered from the moment that you were ordered.
No.
So as of now, you understand that you're in arrears for not paying child support. Okay. Okay. All right.
I'll call myself as a witness very briefly, Judge. and
Go ahead.
My name's Alexandra Yanes. I'll admit Exhibit 11, which has already been admitted as a summary of my testimony, Your Honor. I testified to this court that I'm a third-year associate attorney practicing family law in the Dallas-Fort Worth area. My hourly rate is that of $300.
Objection, she is as an expert witness.
This is her testimony regarding the attorney's fees portion. So she would be an expert on,
Or prior to,
did you serve her with discovery?
it's.
I named myself as a witness, Judge.
Right, but
I did serve myself as an expert judge.
But
I did. Give me a second. I'll-
that was made. That was-
so you served discovery on her?
Yeah.
Okay.
And the response.
Oh, through your prior attorney. That's right.
Yes, this
Yeah,
9 months.
he served it to me, not through his prior attorney, and I didn't name myself as.
No, my prior attorney,
Okay, you all cannot speak over each other. I cannot keep up with what my court reporter is writing down. So you have to speak one at a time. Just so we're clear, there's an objection made to her testifying about attorney's fees because you're saying she didn't designate herself as an expert, correct?
Yeah, well, the document that they tried to designate as expert was not on that time for according to the court's rules.
Okay.
Judge, may I admit, my responses to request for disclosure as my exhibit 13, Your Honor?
So I object that being as part of
It's
the
rebuttal, Judge.
testimony because it should have been filed with the court prior to this. That's part of the pre-trial. That's part of the rules of court.
I don't necessarily disagree. However, this is the first time that you're making an objection to it that I'm aware of. It wasn't brought up. You all had two previous exhibit conferences with Judge Lee, and you never objected to whether or not she
Did
was
that
an
after
expert.
the conference.
Didn't.
What's the date of that?
Judge, may I, submit my exhibit 12?
That is submitted after the conference.
Exhibit 12,
Was served on respondent June 16th of 2026, Judge. And it names me in response to request number 6 as an expert.
and you sent this, which day did you send this to her for her to respond?
That was back in November. The original discovery was by my lawyer, was filed back in like October and November last year. That's why I said it's not only late by discovery rules, it's also late because it wasn't submitted to the court as far as the court rules.
Do you have something showing that you responded after that period? The 30 days from
You mean my
October?
service notification, Judge?
Yes.
I don't have my receipt, Judge. No.
No, not service notification. The response. So he said it was filed in November, October,
Yeah.
November. Do you have a response from that period? Because this period says June 16th.
I don't, Judge. I don't. However, it is rebuttal. I'm submitting it as rebuttal evidence, Judge. And Your Honor, a witness may be allowed to testify if it was not a surprise. It's not a surprise, Judge. We had a pre-trial hearing that said that we were requesting attorney's fees. My exhibit 11 has already been admitted into evidence as a summary of my testimony, Judge. If the court wishes to consider it that way rather than my testimony, not only that, Judge, I've already called myself as a witness. My testimony has already started. His objection is not timely.
You had submitted the document. I'm objecting to that document
Oh, he's objecting. You're objecting to the document, not her testimony.
and her testimony because that would legally she can't give testimony if she wasn't listed as a legal witness, and she needed to supply that to court. And
So is this supplemental? Is this the first response?
I believe it's the first response, Judge.
Yeah, then counsel, there would be an issue.
Like, I submitted them in the form of pre-trial disclosures, Judge, but I don't have anything showing that he served me with request, Judge.
Your pretrial disclosures were filed when?
and they were laid off.
The June 16, it's those.
Order pretrial, that was April. So you're saying this June is from pretrial?
Yes, Your Honor. That's what I have it in my discovery list as.
Am I allowed to see that document?
Yeah, I mean, I was looking at it, so here, you get an opportunity to look at it. Do you have a copy for him?
That is my only copy, Judge. I did not anticipate that I would need it as.
Okay,
Yeah, this doesn't even show. This shows nothing. She don't have a certificate of service, nothing. This is
A
not.
certificate of service.
well, certificate of service is on the bottom of the first page.
This wasn't filed June 16th.
Okay, so
That was-
the document won't come in, so I'm sustaining his objection in terms of the document. She can testify to, I mean, exhibit 11 is in evidence, so I can't overlook it. It's in evidence, so I mean, I don't know what you want me to do with that. She can testify to what's on this document in terms of her fees that have been her client's fees that have been incurred as it relates to exhibit 11.
May I proceed, Judge?
Yes.
And Judge, as part of our requested release, Judge, we're not asking for the total amount of attorney's fees that my client has accumulated. Instead, what we perceive to be as reasonable and necessary pursuant to the issues that are brought before this court. Mr. Lesby is correct. We shouldn't even be here, but we're here because he intends to gain credit of a pension account, which he already knows the court is not entitled to allow him a deduction on, Judge. Secondly, Your Honor, in support of that, he cited AI case law, Judge, which he knew after I requested that he just produce me those cases. He knew that it would reasonably incur my client more and additional attorney's fees as a result of his actions, Judge. And secondly, we've had 2 exhibit conferences, about 4 entry hearings. His testimony that there was no income withholding, we couldn't enter an income withholding, Judge, because he just propounded unreasonable objections to our temporary orders, Judge. So we are asking that this court consider Mr. Lusby's actions and order reasonable attorney's fees to compensate my client for the fees that were incurred in this case, Judge.
And what is that amount, counsel?
We're requesting $3,000, Judge.
Okay, does that include expenses?
That does include expenses, Your Honor.
Okay, all right. And Mr. Lusby, this is your opportunity to cross-examine her on her testimony, which relates to Exhibit 11.
My cross-examination on that would be that I don't believe that I forced her to incur any attorney fees.
No, you have to, it has to be a question. You have to question her.
Okay, question.
Yeah, you don't have to, but you can.
How many hours did you spend working on the case
Sure.
total? And Judge, you said a minute, a while back that they only 2 minutes and I haven't had a chance to testify. I'm not sure.
No, this is her, that was her time. You have 11 minutes and 2 seconds left.
Why is this she testified as far as my time? Is this this is my time that I'm supposed to be testifying? Why is she talking?
You're asking, no. She, she called herself as a witness, so it went against her time. She has 34 seconds left. Now that you are questioning her, your time starts.
Okay,
Go ahead.
total time spent on the case, an hour.
Sure. My time up to this trial date was 21 hours and 21.62 hours. And then approximately an hour for today,
And your hourly,
$300.
and you're testifying that I caused how many extra hours of work?
My client's total attorney's fees is $6,450.
That's not what I asked.
50 cents,
I'm asking you, how many hours I caused you to work extra?
approximately half, Mr. Leslie.
How many hours would that be?
I mean 11.
So you spent 11 hours researching that case?
No,
That's your testimony?
no,
Okay, how many hours did you spend researching the case? That you said, submitted false testimony?
approximately an hour and a half.
An hour. And was it not your testimony that that's what caused you extra work? Was that case law that cited?
Yes, partially.
So you're saying that was the extra work that I caused you, and it caused you 1.5 hours of extra work,
Yes.
but you're asking for over 3,000 attorney fees,
Yes.
right?
No, I'm asking for 3,000.
Yeah, but your hourly rate's 300,
And
and your testimony is that I only cost you 1.5 extra hours of work.
No, that's not my test.
That's all I got, Judge.
Okay, thank you. Anything further, counsel? You have 34 seconds left.
Just that the court consider exhibit 11, Judge, my testimony is that the research was just 1.5 out of the 11 I'm requesting. The other 9.5 relate to the multiple entry hearings, the multiple exhibit conferences, and the multiple email correspondence between him and I.
Okay, thank you, counsel. All right, Mr. Lusby, this is your opportunity to put on any testimony you may wish to. It was something I was getting ready to tell. I was going to ask you, Mr. Lusby,
Mhm.
were those cases generated by AI?
I mean, Google, I guess, on the computer.
Okay. Okay,
I mean, I Googled pension payments in Texas and whatever, and that's what popped up.
okay.
So
I know what you're referring to. When you type in something on Google, the AI
Yeah.
pops up
well,
and,
yeah, maybe I don't know.
Okay.
I didn't even understand at the time that this is an email thread. We weren't in court. I
Mhm.
wasn't submitting something as evidence. We were just on an email thread with the judge, like, okay.
I guess what I'm trying to hint at, that you didn't take those cases and look them up to see if they were actually legitimate cases?
No, I did click on them and look information on them, but and it did kind of apply, but not technically to the pension. So there was no reason to try to submit support.
Okay,
I did try to look for specific stuff like Texas municipal retirement system, because that's kind of similar, or anything like that.
I understand. Well, this is your opportunity to give any testimony that you may have.
Okay. As part of my testimony, I do feel like it's in the best interest of everybody involved that as net resources, it specifically states that pension contributions, if they fall under non-discretionary retirement plan, which my pension contribution is a non-discretionary retirement plan, and also I do not pay Social Security. Both those things are true. I do not pay Social Security, and I'm required, as my testimony, that I'm required as part of my employment with Dallas Fire Department to contribute to the pension. I have no say in it. There's a set amount that comes out of my check, 13% that comes out of my salary. That's part of that. So I feel like they should count as part of the net contributions. Also, my union dues, which was already ruled on and approved. The deductions were basically credit for health and dental. I'm asking for credit for both of those. And actually on the
1 second, in the health insurance, and just so you're clear, whenever I stop and ask you all questions, I stop your time. I don't run your time against that. So on I'm looking for the child support amount in the temporary order. It says
He was giving credit for that.
so the 1347.67, that includes credit for union dues, health insurance, dental insurance, as well as the pension?
Yeah.
Okay,
So the only issue we're contesting is the pension.
okay. I follow you now.
It does not include both minor children. That was computed at 17.5% versus 6%.
Well, that's what I was waiting on you to tell me. Okay, so,
Part of my test, 2 minor children under the age of
and these are your biological children?
children.
Okay,
And Judge, I'm sorry to interject, but I do think it's important. One child was born after the temporary order hearing, I think, because we weren't given any proof. One child, one of the two was born after the entry of the temp orders.
oh, so they wouldn't have been
They
included?
wouldn't have been included. So it was computed at 17. I think he's requesting the 16%.
Okay,
And I did not know of that, Judge. My client didn't know of it until we had the exhibit conference, and we still don't know because he didn't provide the proof for it. I understand his testimony is sufficient, but that's the reason why we computed the 1,500 in our summary of requested rebates. We had no knowledge.
that's fine. Like I said, you all are here today, so we're going to take care of any loose ends, which is why I'm stopping and asking questions, because I don't want to miss anything in computing this child support. So 2 other children, health insurance, dental insurance, union dues, and the pension is included in here.
But the health insurance, I'm not sure the compensation is correct.
What is the amount you pay in health insurance?
Pay $800 monthly, and it clearly states in the Texas law that you divide that number
By the number of people on there?
minor children.
Well, no, it's about the number of people that are on there. So it's $800 a month. How many people are on there?
5. Oops, says minor children under 18.
I don't believe it's 800, Judge.
What is the 600 amount that was on that? Oh, that was for 2025. Did your health insurance go up from last year?
Which document?
It was exhibit.
My exhibit 5 is what he gave us on his benefit.
So my exhibit 1, Judge, would show the current deductions for this year. And if you look at my exhibit 1 on page 2 of 3.
Judge's exhibit 1 is a summary.
No, exhibit 1 I have for him is a paycheck stub.
Oh, that's all he gave me.
Okay, so what I'm also looking at Mother's Exhibit 5. It shows your plan. It shows employee only, employee plus spouse, employee plus children. And if I divide it by the number of people you told me, it is exactly $160, which is what I'm
The
looking at.
40, you're dividing, that's a bi-week amount. So monthly it's $800.
No, it isn't, Judge. It is,
It's 800 monthly.
Bi-weekly,
it is bi-weekly. It's,
so every,
So it's one,
Yeah.
so it's 320.
it would be 800 divided by 5. I think it's 800 divided by 3. It's supposed to be minor children.
No, it's the number of people on the plan. So it would be the 160 then, bi-weekly.
So 800 divided by 5.
160.
Okay.
All right.
It is, if you look at exhibit 1, it shows Blue Choice copay plan 403.79 on page 2 of 3.
Okay, I was gonna ask you to point that out because there's a lot going on this paycheck stuff. So the
Plan B is
Blue Choice copay plan,
Yes, so
Okay.
that's 403 per paycheck.
403.79 divided by 5. Hold on. 403.79 is 2. So that's 807.58 divided by 5. Yeah, that's like 162.
yeah, that's what I'm getting to. Now, Mr. Lusby,
You must have just understood.
No, he is.
but if we're contesting the issue of the insurance, Judge, I do think it might be 6 people on the plan because there is an older child that he was covering.
How old is that child now?
I have 5 opinions, so 6 include me, 5 opinions. You
So-
just seen in my oldest child.
So it is 6 people.
So it's 6.
But that's not what the law states.
Listen, I've been doing this a long time, and I do know that it is the number of people that are on the plan. Because if that were the case, a lot of people's child support really would be non-existent if that were the case in terms of their credit. So what was that amount? 807? Should have written that part down. So
So 154.062E. Deduction healthcare. Divide total cost by number of minor children. State record in Texas.
What section is it, Mr. Lusby?
154.062E. Deduction of healthcare. Divide the total cost by the number of minor children, which in this case would be 3.
so then the health insurance is wrong in here then for the child support.
Yeah, because I'm telling you, Judge,
So the child support from the temporary order is just wrong.
Yeah.
it is because
Okay.
there was another child born and he's just now disclosing how many people are in the plan, Judge. So he was giving a higher credit based on an estimate that he represented to Judge Lee in temp orders. But now that we have the documents, it shows otherwise.
Hold on.
The exhibit.
We're just going to start from scratch with the amount.
This can't be much.
So no, remember I told you when I stopped it is. Okay, so that's giving me 269. All right, dental. How much is it?
So that's also part of exhibit 1. That would be dental PPO. It's 57.89
Per paycheck.
day.
And we're dividing that by 6, right, Judge?
No,
The law is really
No.
close.
by 3.
Your Honor, but he has 4 children and he's got his wife. It allows,
He's
for the-
minor children.
He's paying for the family plan. He's not paying for a plan that only covers the
The law
children.
doesn't state that
He,
either way it states.
Is
The
this
plan
wrong,
divided
Judge?
by minor children.
Okay, what's the section? We can all read it together.
154.062 is what I found.
6-2.
I think that's what we read earlier. Maybe that's a different section.
Five, four.
It says in calculating the amount. Are you there?
I'm here,
Counsel?
Judge.
Okay, in calculating the amount of deductions for health care or dental care for the child under subsection B5, if the obligor has other minor dependents covered under the same health plan or dental insurance plan, the court shall divide the total cost to the obligor for the insurance by the total number of minor dependents, including the child covered under the plan. So his oldest child wouldn't fall under that. That would be considered an adult.
So when you read that,
So it would be 3.
Judge, I don't think that's the way that it's being read is correct, Judge. Let me.
it's pretty clear, but
I don't, one thing I don't argue with is the Texas legislator. This is what they said, and this is what I follow. So if I divide this, I got 115. So I'm looking at his paycheck stubs.
Judge, does that mean that the court is giving him credit for what he's paying on his own health insurance?
No, the court is giving credit for the 3 children, the 3 minor children that he has.
But the health plan covers him and his wife. So the court is giving him credit for what he's paying for his health insurance and his wife?
this.
No, it says if you look at his exhibit 5, it has employee and spouse, okay? And then it breaks down the employee plus the children. I'm looking specifically at that because for himself, he's only paying $56. For him and his spouse is $357. For the children alone is $160. It doesn't break it down by child. It breaks it down by him and however many number of that could be however many children that he has. And then what I'm also looking at is the employee plus family. So that's 403.79. That comes out to the 807. 807.58, whatever that calculation was I just did. That's what I'm looking at. And then if you take that number, that 807 number, and you divide it by the number of minor children, which his testimony says is 3, including this one, that comes out to 269. So he's paying 600 or so odd dollars for his portion, his adult child and his wife. Only part he's getting credit for is what he's paying for the minor children would be 269, those 3. And it's the same thing with the dental. It's giving me 57.89. That's on his paycheck stub.
269 is what you're giving him credit for on the child, on the medical support on Catherine?
Says divided.
Yeah, it says you divide it by the number of children. You take what he pays and you divide it by the number of children. That's specifically what it says.
Okay, Judge.
So the number of children he has will come out to 269. His dental, according to his paycheck, is $57.89 biweekly. You multiply that times 2, you get 115.78. You divide it by the number of minor children, it comes out to rounded up $39.
Okay, Judge.
Then what are the union due? Are they on here?
So yeah, union dues are part of that. That's also part of 154.062.
No, I got that part. Where is it on your paycheck stub? Is it labeled as union dues? Because I don't see anything that specifically says union dues.
So it says DFFA.
Oh, I see that. I see DFAA. Okay.
I think they rounded up to 70.
$70.
While we're on there, I would like to point out the plan B is my pension contribution, which is 658.
I'm not giving credit for that. Because in order for me to give credit for that, for me to feel comfortable doing that, I would need something from your employer saying it is required for your job. Without something written from your employer, I don't feel comfortable doing that because the law specifically says that it has to be a contribution that is required for your employment. So I would think a letter from your employer on letterhead would have been sufficient to show that that contribution that you're making is required for your employment. I don't have that in front of me. And I would need that to consider it, especially considering the email in evidence from the Attorney General saying that they do not give credit for that.
Even though 15.54 specifically states for the purpose of subsection D6, a non-discretionary retirement plan is a plan to which an employer is required.
I don't have anything in front of me. I don't have anything in front of me that shows that is non-discretionary and that it is required as a part of your employment. I think the best evidence for that would be an a letter from your employer stating that as such. Even though you're testifying to it, people come in court and lie all the time. So we can't act as though that doesn't happen. So without something from your employer, I'm not giving credit for that. So given the amount, it said in 2025 that your pay was 125,000.
Yes, Judge.
All right.
That's what we use, but his testimony today is that these aren't earning more.
Completely transparent.
What is the additional, because you did say that there is slightly more, is what you said exactly.
So
What is
as
the
of
slightly?
today, if you look at exhibit 3 that I filed with court,
Okay, hold on. Let me grab it. All right, I have it.
about transparent.
I have it.
So it shows my total salary and allowances. This shows the hourly pay. I know it's kind of confusing. 47.42. So I work 28.08. That's the hours in a year that I work. So if you multiply that by 47.42, you get something like 132.
So it's 130. What, say that again. You said 47.42.
47.42.
And you said, is it 2,808 hours?
28.
133, 155.36.
One 133, 155
36.
So the fact there's no social security taxes also doesn't kind of show that I'm in a defined pension plan, because normally that doesn't happen unless you're in a defined pension plan.
I can't say what normally happens because I'm not in the business. I'm not HR. I'm not in the business to know. And even if I were I had some knowledge of it, I can't impute my knowledge into this. Legally, I can't do that. So the best evidence, as I stated, would have been something from your employer saying that in lieu of Social Security, you have to have this contribution that's required in order for you to be a firefighter. I don't have that in front of me. So, and counsel, y'all can check this math. When I divided that 133, I did 133, 155. I divided that by 12. I got $11,096.25. So if we just take $11,096, I'm looking at the chart here. Do you use the calculator?
I did, yeah. So
Okay.
I got the same thing you got, and then I took off medical, dental.
Well, I can't use yours because you gave yourself credit
I did.
for the pension. So I can't use yours. Let's
Did both
use
ways
the,
on the paper over.
Okay, Judge. I can run the child support calculator if you tell me what amounts you're getting him credit.
I'm giving him credit. Health insurance, he's getting credit in the amount of $269. Oh, sorry, hold on. That's 3 children. I didn't divide it. Sorry, that's my missing step. It's $90 for Catherine. Sorry, it's $269 for all 3 children.
So you're using what?
The
The whole wage you come.
OH,
Where are you getting that from?
So your health insurance, based on your testimony and your paycheck stub, you have 3 minor children. So the credit for the 3 minor children would be $269. You divide that $269 per child. So each child, you're paying $90.
But well, that's not the way to read law.
And then the dental is 39. I didn't divide that by 3. So that'll be $13.
No, it's 39. That's
$39 for 3 children.
I don't think you're doing you're looking at the biweekly amount divided by.
That's the total.
No.
So it's 57. So the paycheck stub that you gave me, the dental is 57.89. 57.89 times 2, that's biweekly. That comes down to 115.78. You divide it by 3, it comes out to $39 per child. Is $13.
Why are you so divided by 6?
No,
You divide it by 3 and then you divide it by 3.
per child, each child. Catherine is 1 child. They're not 3 kids in this case.
You're not taking the total amount divided by 3. You're already divided by 3.
I took the
That's right.
57, the 115, I divided that by 3 for your number of children. You wouldn't get $39 on a dental plan for 1 child.
So I'm getting 39. So you're saying it cost me $13? That calculation's
That is-
Yeah,
I've never seen it done that way.
that's how you do it. Like it's per child. It's not for all 3. You have 2 other minor children. You're responsible for paying them.
So
She shouldn't have to. So in essence, if I give you credit for $39, right? That means that mom over here is in essence paying for 2 of your children. That's what you should be paying for. Well, not paying for it, but she's not receiving the benefit for Catherine specifically. You would be.
I mean, I was just saying divided by the total cost.
Yeah, yeah.
And then the union dues, judge, are $70, you said?
Yes.
Per paycheck.
Per paycheck. No. It's $35.99 per paycheck.
Okay.
So I rounded up $70.
Okay.
So it's 90, 13, and 70.
And then he's got 2 children outside of the action.
Yes, so that would be at 16%. And what is that amount?
I get 1336 with 2 cents.
It didn't really change. So that means that I really wouldn't touch the child support. It didn't even increase by $100. So your child support would essentially stay the same at the $1,347.67.
That's fine. That's because he had another child, right?
That's because you had another child. Although your income increases, which is common, income can increase, but having another child, it can make it the same.
As part of our requested relief, Judge, we had requested a retroactive increase from the time. Would the court entertain that
Yes.
request? Because he didn't have the child until. I'm not sure.
What do you mean?
Retroactive from the date of filing the modification or the date of the temporary
The
order?
date of the temporary.
All right, so,
February 1st would be because the child returned to mom sometime in January.
and let me just go back to your original petition to make sure the request is in there.
So,
Is this from September 2nd? Okay, yes, sir.
so the original amount ordered was like 1080 back in February. So shouldn't it not be based on that amount? And that's part of the reason they never filed an income withholding order, I guess, or put the
1080, you talking about child support?
Yeah, the original amount that this order, I believe it was in March. It was like $1,100.
March of this year?
March of this year. That was with pension contributions. That was based off the old salary. And pension contributions and 1 child outside the action. And it's about $1,200, which that's the calculation they came up with. Overa and John, I had no, besides submitting my evidence of pension contributions, I had no say really. That was the health. The health at that time was 160. I got credit for 160. I don't know why that changed. I'm still confused on that. Because you should take what the employee plus children would take. It should be the employee plus children.
Right, that's
Whatever plan
correct.
that is,
Mm-hmm.
how much that costs, and divide that by maybe 3.
That's what I did.
And
That's how
that's
you,
two.
that's how, no, I divided by 3. That's how I got to
So
90.
maybe that's why I went down, but it seems like it went up.
Correct. That's you, what you just said is exactly what I did. Okay, so there is a request for retroactive child support. Mr. Lusby, do you have access to their original petition?
And Judge, it's not retro, I'm sorry, I phrased that incorrectly. I'm just requesting a clarification based on this court's orders and Mr. Lesby's income from the date she received the child. So I guess it wouldn't be retro, because I'm not requesting anything.
Oh, okay, no, okay.
I'm requesting like an arrearage confirmation.
Yeah, we did use the wrong word.
Yeah, that's my.
Let's see. Well, his amount is staying the same. So you mean from the
His amount. is
1,300?
His amount is staying the same now that he has 2 children, but if we were to calculate it January, February, March, and April, I believe the child was born in April something. Giving him credit for 1 child out of the action would amount to the child support being $1,461.27.
Say-
those months.
1,461.27.
Yes.
There was a object because there was an order by Judge John Lee at the time for an amount of child support to be paid, and they never followed the income.
Just so we're clear, her name is Jean Lee,
Jean Lee.
not John.
Okay, me too, I didn't.
Announcement.
When you said it the first time, I thought you misspoke.
I thought you were talking about OAG.
Okay. So you're saying the difference, the $113.60.
I'm saying that for the months of February, March, April, he shouldn't be given credit for another baby that was not him.
So the child was born in what month? So it would be January,
Not
no,
January,
February and March.
February, March, and April. The child.
He said the baby was born in April.
Okay, that's fine. There's February and.
When was the child's birthday?
I'll show you. I have no problem showing you, but
Okay.
I really not.
So,
Well, I mean, this is to help you. So you can choose not to say anything.
I mean, I'll show you the document that shows his birthday.
you
I
could
can
just
give it
say
to
his
you.
Birthday.
No, I don't need her to know. I don't want her to know. Y'all don't understand.
Okay.
I don't care.
Can I see the baby's birthday? Oh, it's up here. Okay. I'm like 80. That's you. Okay, I got it. All right. So it would be half of April.
That's fine, Judge. If we can calculate it for February and March.
I objected that just because it was already an order for child support.
And I'm
If-
requesting a confirmation.
She's requesting a confirmation on what your child support should have been before you were given credit for a second child, because you technically shouldn't have gotten credit for February, March, and half of April because your child wasn't born until later. Does that make sense?
They filed an income withholding and they would have taken child support out of my check at the time and say it was 1,200.
Mhm.
Would the court go back and say, oh, it should have been 1,400 and add extra to that?
Yeah, because the income with
Because that's
the
subjective. Like, if the judge at the time orders an amount of child support, you're not gonna go back 10 years later and say, that was wrong.
like I said, this is where it gets corrected. Whatever should have happened or didn't happen gets corrected here now. So the amount, which amount are you looking at? What, the 14?
1461 with 25, Judge, and that's using the same calculations. I'm not even removing the credit for the health insurance for this third kid. I'm just the way that it is,
But
Judge.
then the calculation for the health insurance is also off, right? Because you're doing it by 3.
Yeah, that 1467, would that number be right if all of the
Because then you would only be buying the health insurance and everything.
The only thing I'm changing is the number of dependents, Judge.
You got-
That's what
I don't know if I like that, counsel, because it was wrong. We just did it all today,
You
right?
can
So
recalculate it, Judge.
yeah, that would be better. Do the recalculation because you were given credit in that child support amount for a child who wasn't viable yet.
No,
Yes,
how was that?
When you went to court, did you tell the judge that you had 2 other minor children?
And
It's a yes or no. Did you tell the judge?
Yes.
Okay,
when
then
it happened,
that was not truthful because you didn't have a child until April. So if you went to court,
no.
okay, so maybe let me rephrase my question. When you went to court before April of
Okay.
2026, did you tell the judge that you had 2 minor
No.
children? Okay, so, but this 14 number includes the pension, right?
yes.
Okay, so yeah, we have to redo it.
I don't know what it
So-
includes, because the original child support amount back in March.
Okay, we're not
$1,200.
gonna
That
even,
includes the-
any child support that was calculated before today, we're not revisiting it. I didn't change your child support because your income didn't even, although your income increased, you having another child, it's only like a, what? $30 difference, if that is not much. So it'll stay the same.
Now, Judge, if I may, for my claim on confirmation of arrearages for February, March, and half of April, the court stated, if we recalculate his medical support obligation, it was 90 with 3 children, with 2, it gives him a credit of 135. It was 13 on the dental for 3 children, for 2 children, it gives him a credit of 1950. And giving him credit for the union dues of $70 a month, 1 child in this action, 1 child outside this action for that time period. His child support obligation for February, March, and half of April would amount to $1,452.26, Judge.
That was the-
42. So it'll be the full month of February, full month of March, and half of April. How would I,
think for efficiency purposes, Judge, we'd accept the new amount for April.
for April?
Yeah.
Okay. So then that'll just be 2 months.
Yes, Judge.
Two. Oops. Hit the wrong button. So it'll be $2,904.52. That's confirmation on arrearages.
So this is.
But no, yeah, that's confirmation of arrearages. But we need to break down no, there wouldn't be an arrearage on that. Never mind.
It is an arrearage, Judge, because he didn't pay any support for February, March, April, May.
I was not child support. I was thinking medical, but she's been on his medical.
Yes.
So the amount confirming arrearages for what you did not pay, even based on your testimony, you said you didn't pay it, is $2,904.52. I'm going to do a payout on that. That's what you will pay to pay down the arrearages.
$2,900.
$4.52.
And this is for.
Oh, is this the?
That's just for February and March, Judge. He didn't pay April of 1336.02. He didn't pay May of 1336.02, and he didn't pay June of 1336.02. July is not over yet, so his arrears will be confirmed. We need to confirm all the months he hasn't paid.
So this is just for, let me make this note. 2/26 through 3/26. And what's the time period for the current amount?
April, May, June.
Through 6/26. And that's at the amount, the current child support.
Yes.
Your current child support remain the same,
So 1347.
1347.67. So the arrears Let me make sure I say this correctly for the record. So the arrearages that are being confirmed for the month, for the period of February 2026 through March of 2026 is $1,452.26. From the period of April 2026 through June of 2026, the confirmation of arrearages is $4,043.01.
And
And-
for the other 2 months, I'm sorry, I think there's
1452.26.
That's multiplied by two, Judge, because it's February and March.
Oh, that's the full amount.
Yeah, it's the full amount. So
Okay, let me strike that. I'm going to round this 1,452.26 times 2. Yeah, Daddy. I said it.
yeah. It was probably really correct because you had already said it, but
Yes, I did. So the period of February 26th through March 26th is $2,904.52. The period of April 26th through June 26th is $4,043.01. So for a cumulative judgment amount, cumulative judgment is $6,947.53.
$6,900.
$47.53.
That's through June.
Well, I don't want to say through June because the periods are different. Just write it down by period. So that 2,900 amount that I gave you, that's for
Yeah.
1452 for February, 1452 for March. And then after that is the regular child support amount, April through June. So I'm assuming that'll be like June 30th of 26. So $6,947.53. That is a child support arrears judgment in favor of mother. Let's do a payout amount. I'm never good at those payout amounts. I normally let the AG tell me.
So should we, I
Let
mean,
me
I paid
see.
child support on time for 10 years. Can we not allow it to be something I take care of with the AG on my own versus having a payout amount?
Well, the AG does a payout amount. So this what we'll do. I'll put the payout amount in here. Now, if you go to the Attorney General and tell them that, hey, I want to pay it in full, that'll just drop off. Does that make sense?
Yeah.
So the payout amount
Usually
usually is,
they put an income withholding order in with extra on top of the 30.
it will be in there.
And then it not coming off after I pay.
No, it
There's not a
will.
mess up there.
No.
They're not.
The Attorney General, the way their system is really good about this, that income withholding order plus the final order that's going to be sent to them, they should say the same thing. And if there were an issue, they wouldn't be able to withhold. They'll let the court
I did
know.
want the court to be aware of that I got a income withholding order from the Attorney General yesterday. That
Was it for this amount?
I don't know why it was generated. Maybe they can.
there was an
States-
income withholding that was signed by this judge.
Oh, yeah. So that means they have the temporary order too.
No, they have a temporary order. There is no income withholding. I'm sorry, Judge, I misspoke, but my client received it too. What they received is a confirmation that they switched off the board.
I don't think the income withholding that was signed by this court was ever filed with the Attorney General that I know of. I talked to him yesterday.
You're talking about the termination of income withholding?
That I believe was. I'm talking-
Yeah, I have that one.
The income withholding that was signed and made by Judge Jane Lee, I'm sorry. Jane Lee.
Yes. And that's
It was never
fine.
submitted to the Attorney General, because they don't have it, but I received one yesterday that said it was prompted by a Title IV response of somebody applying for benefits and it was totally wrong, like it didn't even have my employer right.
Well, then in that case, I will tell you to just speak with the Attorney General on that. That's something that you can fix on your end. The payout amount, I'll do $100. So essentially, on the income withholding order, let me explain to you how it's going to look. It's going to have the payout amount of $100, and the 1347 is going to be on the first line. You've seen an income withholding order, right? It'll be on that first line. the $100 will be on the next line. And then at the bottom, it will have it broken down how much money will be garnished out of your check based on how you get paid. So bi-weekly it'll be on there. Does that make sense?
I think that's right.
Well, that's beyond what I am paid to do. That is the Office of the Attorney General. So the payout will be at $100. We're in the month of July, so we'll just say, what's today's date?
The seventh, Judge.
So we'll just say 8/1.
8/1 is when this income withholding order will,
No,
oh. I'm sorry.
not 8/1 of the income withholding order. I have to be very particular. 8/1 is when the $100 obligation, the payout would start.
8/1 payout, and
Yes.
the rest of it will be dated today or a couple of days from today.
What do you mean?
And the income withholding.
The income withholding order won't be signed by me until I get the final order. So what's going to happen now, I'm making my ruling about the confirmation of arrearages. I told you your child support is going to stay the same. That's giving you credit for your 2 other children, health insurance, dental insurance, as well as union dues. As far as the attorney's fees, the court is going to order that each pays their own attorney's fees. So the request for attorney's fees is denied. What I am reserving, like we stated at the beginning, is the possession and access until after I speak with the child. And, you know, I told you prior to going on the record, I made that decision because based on your own testimony, you haven't seen her any of this year.
Yeah.
Okay. All right. Is there anything further for the record?
Nothing further on our end there.
All right. Well, you all,
Um,
oh, yes, sir.
the income withholding order that was submitted prior, I guess the good thing never got submitted, I had my social security wrong. Security number in, it's incorrect.
Oh, we'll get it right this time. We'll get it right. Do you have his correct social
I don't,
security
sir.
number? Okay, so,
I just
The
need the last,
Attorney General definitely does, because the one they sent yesterday had my
I just need the last 3 digits for the income.
okay, so